My name is 𝗁𝗵𝗀𝗆. I'm a solicitor advocate at 𝗵𝗵𝗀𝗆, and in this video I want to look ahead at some of the important procedural changes coming into the UK employment law in 2026, specifically new tribunal deadlines and much tougher penalties for redundancy consultation failures. Now, these changes don't just tweak the system, they fundamentally shift the balance of risk for employers and opportunity for employees. They are designed to give workers a fairer chance to seek justice and to push employers to follow proper processes, particularly during dismissals and large-scale redundancies. So let's break this down slowly, and employers, buckle up, because change is coming. At the moment, most employment tribunal claims, including unfair dismissal and discrimination, must be brought within 3 months minus 1 day of the act complained about or the end of employment. From October 2026, that window will double to 6 months for all claim types. Now that is a significant change. For employees, it provides breathing room. Losing your job or experiencing workplace mistreatment is often overwhelming, and that deadline gives time to raise internal grievances, explore ACAS early conciliation, seek legal advice, or simply regain some of that stability you need before deciding whether to pursue a claim. You're no longer forced to rush legal decisions while processing still what's happened. That said, 6 months is not a reason to delay indefinitely, as it were. Evidence can fade and memories can change, so early advice still matters, but the pressure is reduced. Now for employers, this means a longer period of uncertainty. A dismissal in January might not turn into a claim until July, or as far as the employment tribunal backlog is concerned, even later than that. And that makes record keeping critical. Employers, you should retain investigation notes, warnings, meeting records, and correspondence for longer. Avoid assuming you're in the all clear after 3 months. And expect disputes to remain live for longer. The upside is that the longer window may encourage earlier settlement or resolution through ACAS if it's used strategically. But now I want to talk about the much higher penalties for redundancy calculation failures. This is the second major change. When an employer processes to make 20 or more redundancies within a 90-day period, the law requires collective consultation with employee representatives or a recognised trade union. Now currently, if an employer fails to consult properly, an employment tribunal can make a protective award of up to 90 days gross pay per affected employee. From April 2026, that maximum award will double to 180 days pay. In practical terms, this means that a failure to consult lawfully could cost the employer the equivalent of 6 months' wages per employee instead of 3. This change is deliberately designed to raise the financial consequences of non-compliance and to deter employers from rushing, bypassing, or minimizing consultation during large-scale redundancies. So for employers, the message is simple. Consultation must be genuine, meaningful, and properly timed, not a box-ticking exercise. If redundancies are planned, build enough time for consultation, count affected employees carefully, when in doubt, err on the side of consulting, and document the process thoroughly. The financial risk of getting this wrong is now far greater than the cost of doing it properly. And for employees, this significantly strengthens your position. Protective awards are not automatic. They usually require some kind of evidence of failure to consult and often involve group or representative claims. But the higher penalty gives much greater leverage in both tribunal claims and settlement discussions. At 𝗵𝗵𝗀𝗆, we help both employers and employees make sense of these procedural changes, and we apply them properly in real situations. For employers, these reforms mean higher risk if dismissals or redundancies are mishandled. We work with organisations to audit dismissal and redundancy processes against the new legal standards, advise on collective consultation, planning, timing and documentation. We train managers to handle dismissals fairly and consistently, especially as more employees gain unfair dismissal rights. And we support consultation meetings and settlement discussions to reduce the risk of tribunal claims and costly protective awards. Put simply, we help employers put the right processes in place so workforce changes are handled lawfully and defensively. For employees, the law is shifting in your favour. If you've been dismissed or made redundant or treated unfairly, we can explain your rights clearly under the extended 6-month tribunal deadline. We can assess whether you have a strong claim and advise on the best timing to act. We can support negotiation and settlement where appropriate, and we can represent individuals or groups affected by unfair or rushed redundancy processes. The longer time limits give you more space, but knowing how and when to use that time still matters. Employment law is changing quickly, whether you're managing a dismissal or facing one. Early advice makes all the difference. If you're dealing with a redundancy, a dismissal, or a potential tribunal claim, speak to 𝗻𝗁 Law. We will help you navigate 2026 changes and beyond clearly, confidently, and strategically.